My name is Caitlin Johnston. I am your chief judge this morning. And just to check, we have Kentucky this morning, right? Unit 5. Okay. I know Ellen got that right in the first place, but okay. So we'll do a quick round of introductions of ourselves, and then we'd like you to introduce yourselves. Looks like we've got a big team. And then I'll read the question, we'll get rolling. My name, again, like I said, Caitlin Johnston. I am joining you from New York City in my studio apartment, where I work at Peloton Interactive Fitness Company. I'm originally from Indiana, and when I was in high school, I did the We the People program as well. Never made it to nationals though, so thanks for your hard work and good luck today.
Good morning, everyone. My name's Andy Levy. I'm a trial lawyer based in Baltimore. I also teach at both of Maryland's law schools. And I'm joining you from a little town called Highland, which is about halfway between Baltimore and Washington, D.C.
Good morning. I'm Chuck Dunlap. I'm Executive Director of the Indiana Bar Foundation, and I am in Indianapolis, so a little bit farther north than you all. And I'm also an adjunct professor at Indiana University, and looking forward to talking with you today.
Great. Would you introduce yourselves, please?
Good morning. My name is Davis Recht.
Hello, I'm Megan Farney.
Good morning. My name is Ella Barnes.
Hello, my name is Hiren Lemma.
Hello, my name is Ty Hopping, and we represent Unit 5 from the Commonwealth of Kentucky, and our teacher is Ms. Megan Boyman-Hennies.
Great. Thank you very much. All right, let's get started. I'm going to read the question, and when I stop talking, you can begin, and that'll start your time, and watch Ellen's screen for your cues, okay? Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? To what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses? Whenever you're ready.
As a unit, we agree with Richard Posner's assertion that the American people uniquely prioritize the right to privacy over other individual freedoms. This panel employs legal scholar Adrian Luca's definition of privacy as the right to be left alone, or the freedom from business or governmental interference and intrusion.
The American right to privacy was first introduced through early documents including the 1776 Virginia Declaration of Rights. These premature assurances of privacy later matured into the 4th, 5th, 9th, and 14th Amendments, which protected people from unreasonable search and seizure, infringement of unenumerated rights, and violation of due process.
In conjunction, these documents created penumbras that officially established the right to privacy as among said enumerated rights, as characterized through 1965 Griswold v. Connecticut. In the 1960s, as a new social substantive due process came to the forefront, society became more concerned over their individualism and their right to privacy in their personal life.
Throughout American history, citizens have demonstrated a relative complacence regarding restraints on other individual rights, such as restrictions on obscene speech, demonstrated through Reno v. ACLU in 1997. This prioritization of the whole over self is now reflected within the history of the right to privacy. The American public has repeatedly demanded protection for this liberty, a trend demonstrated through the response to Olmstead v. United States.
In this 1928 case, the majority ruled the wiretapping of conversations from within the public sphere, even if said conversations took place in private, did not amount to a violation of Fourth Amendment protections. The implications of such violations to legitimacy of procedural due process, or the necessity of the government to follow fair procedures before infringing upon life, liberty, or property, forced the Warren Court to overturn this decision in 1967 through Cass v. United States.
A similar trend can be seen regarding the relevancy of substantive due process, which ensures protection for fundamental rights not explicitly mentioned, including privacy. Particularly, backlash against the 1873 Connecticut Cornstalk Act, which prohibited the sale or distribution of materials through contraceptive or abortion, resulted in its nullification through the 1965 case Griswold v. Connecticut.
While threats to the guaranteed right to privacy are diminishing on a case-by-case basis, this right is still being threatened today by the government and businesses. Section 215 of the USA Patriot Act further extended governmental jurisdiction established in United States v. Miller. It mandated that any source of public data, including healthcare or business records, are available elsewhere for the federal government to subpoena in an effort to investigate, quote, national security threats. This indifference clearly demonstrates a widening threat to privacy and constitutional liberty.
Moreover, the American public became aware that their personal data was being used without their consent by Cambridge Analytica in procuring political advertisements. Legislation such as the California Consumer Privacy Act of 2018 was henceforth protecting privacy on public platforms.
The courts have further refined the rights to privacy. Regarding rights to bodily autonomy, landmark decisions in 2003's Lawrence v. Texas, and later in the 2015 case Obergefell v. Hodges, extended due process provisions to protect citizens' individual liberties.
As the right to privacy built on the foundation of individualism, it remains a crucial part of this nation and protection for the people. As founding father Benjamin Franklin asserted, they who can give up essential liberty to obtain little temporary safety deserve neither liberty nor safety. Thank you. We are now ready for your questions.
Perfect timing, because I saw Ellen's time card go up. So I'd ask that you put any notes that you have up away, and we'll move to follow-up questions. And I'll start. So I think we got a good overview of kind of the constitutional law. I'd like to focus in a little bit on the concept of privacy violations by businesses. Do you continue to have a right over your personal data once you've signed up for a social media service like Facebook or Instagram? And what does the law say about that?
Absolutely. So a big debate today is whether what you put into certain programs such as Facebook or what you use in Google is technically your data or considered your personal information. And we can see that through the third-party doctrine, it's ruled that it's not yours once you sign those agreements, signing away your rights to those specific information. So that's led to various different cases such as Smith v. Facebook, where individuals are suing Facebook for tracking their location. But when you look into the terms and agreements that the users did sign, that Facebook was then allowed to track that data, and henceforth, they didn't constitutionally have any ownership over their property, over their whereabouts through Facebook.
This is also a problem with Amazon. One of the biggest things that people have in their homes right now are Amazon Alexas. So when people sign up, connect their phone to their Alexas, they get terms of privacy. And there's been a lot of problems with people's Amazon Alexas sharing phone conversations that they've had on their phone or calling random people. And they've been sued for this, but as it is in terms of agreement that Alexa has access to all that information, it is constitutional.
So Oliver Wendell Holmes famously said that the life of the law is not logic, it's experience. And so what I'm interested in hearing from you is your experience and how you think that should translate into legislation. What do you think is, how do you address these problems with ownership of data and lack of privacy?
I think we are in a particularly unique case as students because not only do we have obligations to our familia, but we also have obligations to our school and what we say and the data that they can access via those means. So I think we're in a unique position regarding how much privacy we truly have. But as we've learned, especially through this class, and recognize the various elements of privacy and where we give up those rights in order to gain others, I think the legislation very aptly reflects the state of the country today.
Have any of you ever sort of read one of these agreements that they ask you to agree to and say, well, I'm not going to get on Facebook because I'm not willing to give up that privacy. I'm going to turn off Siri. I'm going to turn off Alexa. Have any of you done that?
I have not personally been super concerned about signing up for a certain social media platform, or feeling inclined to give them certain, or not hold back my certain data. I guess that's just a personal standpoint that I feel as I don't have anything to hide. But I definitely can see in schools where that can be scary, where you feel like that is an invasion of privacy on yourself. But personally, when it comes to a social media platform, I just try to shy away from either posting a lot about myself, but actually like joining the app or the website has not been a huge concern for me.
Going off my colleague Ella, I personally have not also declined registering for a social media app based off of privacy concerns, but I know for school, a lot of people have neglected to like connect their Apple ID to their school computer so that they cannot share their photos with the school and kind of protect themselves in that aspect.
I want to move on. Thank you. I want to move on to get back to the idea of government in this role as opposed to private industry. And let's talk about something extremely current to all of us, the COVID-19 situation and the environment that we find ourselves in. And I assume you're familiar with the term contact tracing and the idea of trying to, identify from a public health perspective. What do you think how should the courts analyze and how should they treat government's interest in tracking movements and doing things in the name of public health and public safety versus the individual privacy aspects that are also implicated?
I think what we can see today is that foreign nations and various governments are running the fine line between totally overstepping the boundaries of privacy between the constituency and the government. Looking specifically, if we look at China, where the outbreak occurred, the Chinese government did require a majority of the citizens to download an app onto their phone, which tracked their location and also set up a standard to see if they were contagious and how they were going to spread that around. They kind of took a more authoritarian way to implement this, and it was a big breach of the privacy of those constituencies. But I think if we look more towards the United States and what they're doing and where we could see the breach of privacy going, I think right now the administration is recognizing that we are guaranteed a certain amount of privileges and we're used to the amount of privacy between the government and its constituencies. And I think if we breach those privacies, I think that's where you'll see the court step in the future. I think right now the interaction between the government and the constituency is all what we're used to. There's a lot of information coming out about which states are doing the best for quarantining. Specifically within Kentucky, we've been ranked very low for keeping the stay-at-home order. And I think all that data has been obtained just as you've been talking earlier with like the Facebook agreements and what we're posting on social media.
All
so
right.
I think right now.
Thank you, Davis.
Thank you. Sorry, we're at time, but I appreciate it. My fellow judges will give you some applause here. Great job. So we'll do a quick round of feedback. I thought that was great. Very, very excellent job adapting to kind of a different environment. I liked your lead with the definition of privacy, the right to be left alone, and your kind of overview of the foundational principles of kind of where privacy has evolved. I would have liked to have heard a little bit more in the discussion that we had in the follow-up questions. I think particularly, this is a world that I operate in, right, which is terms of service and privacy policies. I write those for our customers day in, day out. And I think, great job mentioning the third-party doctrine in response to my question. Davis, I think when we got into where Andy was prodding you a little bit more with some opinion questions, it would have been interesting. I was waiting for you to tie it back to the Cambridge Analytica case, which you touched on in your prepared remarks, but then didn't bring them back in the follow-up. So just a note that, if you find opportunities to share your opinion and then tie it back to, something you've studied in the materials, that's a great way to show us your command of the facts. But you guys all did an excellent job, great participation in sharing what you know and also kind of what you think, which we want to hear both. So, Andy?
Yeah, I was so interested to hear your responses, which, and I agree with Caitlin, but I think, and maybe that my question kind of kind of sort of took you down a sidetrack there, but I thought it was very germane. I thought your answers were very well stated, very thoughtful, and I would have loved to have had more time to talk to you about this, which is quite frankly one of the signs of a really good presentation. It was so thought-provoking. So lots of things you said during your opening that if we'd had the time, I'd like to have followed up on the Virginia Declaration of Rights and all of the Griswold and Katz and so anyway, great, really guys, great job under obviously difficult circumstances, but you really acquitted yourselves very, very well.
Again, I'll agree with my colleagues. The one thing I do want to say too, and I don't think this really counts in the scoring rubric, but technically from the Zoom perspective, you guys were great. We could hear you all. Everybody muted appropriately and didn't talk when they were muted. And that's something I'm still going to be worried about the rest of the day for my own circumstances. But that aside, the content was great. You did a really nice job. And the thing that I really particularly, and Andy, I think was saying this too, when, I would love to have a lot more time because there's so much in this particular question from the privacy rights as it relates to government, and the question I had, I wish we had more time for all of this, but the other idea too, that, it's government, and that's within the constitutional, structure, but also private businesses, which you talked a lot about too. And the technology aspect, and as that changes and increases, it's only going to be more and more challenging. And I thought in your response to the idea of, other countries and how they're handling the current epidemic, other countries don't have the same protections. So I'm getting my sign-off sign too, so we'll keep on track, but great job. Enjoy the rest of, I guess this is the one for your unit, but I look forward to seeing the results in the near future, and thanks for doing this. Congratulations on it.
And a shout out to Ms. Boyman-Hennies for a great team. And fortunately, your parents can't be with us. And so if they were here, I would congratulate them on what a great group of guys that you are, and congratulations. Fantastic.
Thank you.